Mr. Steven, thank you very much for having us. As we discuss this subject, there are a lot of questions from our viewers asking about liquidation insolvency, so we need your help and your professional advice. Before we start, could you please explain what the KSA group is and what services do they provide?
Well, KSA is a firm of licensed insolvency practitioners. We're regulated by the Insolvency Practitioners Association and overseen by the government. So our ultimate regulator, if you like, is the Insolvency Service, part of the UK government. We focus on turnaround and insolvency almost solely. So we're not accountants in the general sense, although most of us are trained accountants or insolvency people. So we have a number of offices across the United Kingdom, from here in London to Edinburgh in Scotland, and we have a back office for most of our insolvency work in Newcastle upon Tyne, and our turnaround office is in Berwick upon Tweed. There are about 23 of us who focus entirely on this type of work. We don't get involved in the law aspect or the accountancy aspect. We're very focused on turning around businesses and looking at situations where they have to be put into liquidation if they're not viable businesses anymore. So it's split broadly down the middle: rescue and recovery, and or liquidation and insolvency like administration. So that's the work that we do.
You use some of the terms, so it might be helpful for our viewers to know what they mean. For example, you said insolvent. What does insolvent mean?
There are three tests for insolvency of a company, and we primarily focus on companies. We don't generally work with consumers or insolvent people who have got gambling issues or things like that. So we're very much focused on companies. And the law is quite specific what the tests are for insolvency. The first one is, can the company pay its creditors as and when they fall due? So for example, paying VAT on the seventh of the month after the VAT falls due, paying PAY on the 19th of the month. If the company can't meet those deadlines, then it's potentially insolvent. The second test is what's called balance sheet insolvency. So does the company have less assets than it has liabilities? So for example, it may have £1 million worth of liabilities, but only £200,000 worth of assets. So it's clearly insolvent. And there is a third test, which has not been that common recently, but is becoming more common, which is called the legal actions test. So for example, a creditor who hasn't been paid on time can issue a county court summons. That turns into a county court judgment. That county court judgment is registered at Companies House and registered with the credit reference agencies. So those are the three tests. Some companies display cash flow problems on a regular basis but can trade out of it successfully. Other companies find that cash flow brings the company to an end. So insolvency means there's something wrong with the business. It means that there are more liabilities than the cash available. And usually, in the final analysis, it's running out of cash that turns a company into an insolvency scenario.
So you use the word creditors. What does it mean?
Well, creditors are people who supply your business with credit. So for example, a landlord, when the company signs up to pay rent, the landlord is a creditor. HMRC is a creditor for monies that you take from people's wages, for national insurance and for income tax, etc. So it's called PAYE, pay as you earn. So the HMRC is always a creditor. Other creditors could be suppliers of product, stock, vehicles, that sort of thing. And there are other creditors such as hire purchase or leasing arrangements for vehicles or machinery, perhaps. All of those are called creditors, and our debtor is somebody who owes your company money. A creditor is somebody that you owe money to as a company.
There are lots of clients who contact Dehshid & Co. and they don't know if their company is viable, has a future, or the company cannot run anymore. How should they decide when to contact you? What is the procedure? How you are going to help them, and what information do you require from them? Could you please explain these steps?
Yeah, look, we know it's a difficult step for people to contact anybody that they don't know. And although we are very nice people, it can be a very scary event to have to think about looking for help outside of your area of expertise. And we are experts in this field. But we treat everybody in exactly the same way, which is we ask a number of questions, we give them all of the options, and then we try and establish a strategy. So the questions are usually about what is the business, where is it, what does it do? Very straightforward questions. So what we need to do is to establish what kind of business is it? So is it a retailer, is it a garage, is it a manufacturer, for example? And if we can then establish what it is, we kind of know the background to those businesses and where the pressure points can be. So the next questions we'll ask are, what do you want to do? Do you want to continue? Or is it something that you feel you want to fight for? Is there a rescue here? Is there a turnaround scenario? And turnarounds are jolly difficult, and in many ways it's easier to stop trading than it is to carry on if the business isn't doing well. So we don't ask questions about viability. We try and establish what it does, what are the issues, so what problems have caused the cash flow to be difficult, what problems have caused customers to... So we ask very straightforward questions, and it's best if people who are thinking about calling us have some basic information. So roughly, what does the turnover of the business? What kind of margin does it make? What kind of profit does it make? How many people does it employ? Does it have, for example, premises? And how much do those premises cost? We'll need to know that information in the first call. But you'll find that the people who handle all of the first calls are very friendly, very approachable. They've heard all of these things many, many times before, but they're trained to ask the right questions to make sure that we find the right answers. Now, usually this can be quite an emotional process, and the people who are calling us, they clearly don't want to be calling us. I liken it to going to see a doctor. You never really want to go and see the doctor, do you? So coming to see our company's advisors is equally difficult. What we try and then do is to say, look, if we were to be able to reorganize the debt, is the business something that you want to carry on with, and can you see it being profitable in the future? Because without profit, clearly there is no future. And if somebody says, no, we're not prepared to continue, we have too many creditors, I can't get enough staff, or we're running out of cash, and I just want to stop, then we'll be advising them on the appropriate solutions to stop. So I always boil it down to this. Is it a go solution, or is it a stop solution? So is it a rescue and a turnaround, and can we help you with this? Or is it a stop and we need to put the company down and put it into liquidation? What I always say to people, and I've trained all of my staff to be the same, is we need to try and take the emotion out of this. People are going to be emotional when they're talking about their business. It's their baby, if you like. So we try and tell them, look, don't focus on the emotion, focus on what's the right thing to do. In our world, we are obliged to give all of the solutions. We have regulatory requirements to tell us that we must take each caller or each contact through all of the options. So we will look at the key options, and they are a rescue, refinance, they are a company voluntary arrangement rescue, they can be a liquidation, or they can be administration. Usually those are all of the options that are available, not that many, but the reality is somebody will tell the caller, look, you can just do this. And usually that's bad advice. You can just put it down and start again. This is bad advice. You've got to be very careful. There are legal requirements on company directors in particular to act properly. And if they don't act properly, then they can be fined or, in indeed some cases, disqualified as directors in the future.
You mentioned CVA. Could you please explain what is a CVA process and how long does it take?
The CVA, in my opinion, is the best rescue mechanism there is. Right around the world there are rescue mechanisms, but we have in the United Kingdom, I think, the best rescue mechanism. And the reason it's so good, in my opinion, is the law kind of got out of the way and said, do a deal. If you can write a deal that the creditors can accept at a meeting of creditors, and those are the people that the company owes money to, then the company can be rescued and we can take the debt right down, in some cases write it off altogether. Now, it's been around for 30 years. There are very few creditors who haven't been involved in some form of insolvency. Most of them know what a company voluntary arrangement is, and that includes HMRC and banks. So we can write a proposal, We put it in front of an insolvency practitioner who then files it in the court.
We have a question from our viewers asking that they would like to consider a CVA, but their accountant or other advisors are advising them not to, because HMRC will reject it. Is this really true?
No, in fact, it's the opposite. Our experience with HMRC is they want to support viable businesses. They want to support companies that put forward proposals which are fit, fair, and feasible. Those are the three key words. So is it fit for purpose? It doesn't have to be too complicated. Is it fair to the creditors? And HMRC are what are called a preferential creditor now, so they come above all other creditors except maybe a bank with a fixed charge. And is it feasible? And that feasibility question is there a viable business? So right back at the beginning when we take the initial inquiry, we are trying to establish, does the director or the directors, do they think there is a viable business? If we put a proposal like that in front of HMRC, they all have a vote, as does every other creditor, and almost always vote. And they almost always vote in favour. And the reality is, they believe that that's a better outcome for creditors, including HMRC, than a liquidation. And in most cases, liquidation does not generate any recovery for the creditors. Now, a CVA must generate a recovery. It's got to do better than a liquidation does. And it will preserve jobs. Those jobs will carry on paying taxes in the future from tax deductions, and it'll generate economic activity. So CVA is very powerful, and HMRC will support it, but only if it's done properly. And what you can't do is simply phone up HMRC and ask for a company voluntary arrangement. It has to be a very well thought through, carefully constructed process. And at the end of it, there's a very large document called a proposal, which is typically 60 or 70 pages long. It will have forecasts in it. It will have the history and background. Why did the company get to this position? And what's it doing about it? And we put that in front of the creditors, and they're entitled to vote upon it. HMRC, in my opinion, are very fair. They're pretty flexible, but it's got to be fit, fair, and feasible. And it's got to be something that they can support. What they will not support is where there has been multiple failures of companies in the past, and where directors have taken too much money out of the business. So this can lead to directors having overdrawn loan accounts. They will want to see overdrawn loan accounts repaid. But generally, HMRC are supportive of voluntary arrangements, contrary to the sort of public belief that HMRC wouldn't be supportive. And bear in mind, HMRC debt collectors are not dealing with this. It's dealt with by a very specialist unit called the Company Voluntary Arrangement Service. And they get to vote and decide whether to support it or not.
So we compared CVA with liquidation. As you explained, CVA is an option that they can continue their business and then arrange to pay their debts. Can you tell us more about the liquidation steps?
Okay, liquidation really should be used for the last resort. If there is nothing else, we've tried all other things, and the business is simply not going to work, then we put the company through a voluntary liquidation process. Now, the steps are quite straightforward. The directors have a meeting, and typically they'll have a meeting with us. We'll take them through all of the options carefully. Then we'll mutually decide that liquidation seems to be the right approach. The directors then have a vote at a meeting, and they call a meeting of the shareholders. Now, usually the directors and the shareholders are the same people, unless it's a large company. And then the shareholders vote to nominate an insolvency practitioner who's a licensed insolvency practitioner to act as the future liquidator. The next step is to put together a list of all of the assets and a list of all of the liabilities of the company. This is called a statement of affairs. And what do we think the assets will be worth if we were to stop trading and go into liquidation? And generally, the assets are worth much less in liquidation. We've all heard the expression fire sale or liquidation sale. So the assets are worth less, and the liabilities rise because you've got redundancies for people, you've got landlords for rent, and so forth. 3 weeks after that statement of affairs has been put together, we have what's called a decision-making process. Now, I'm an old-fashioned sort, and I call it a creditors' meeting because that's easier for people to understand, and I've no idea why the rules were changed, but it is the case that they're now called DMPs, or decision-making processes. At that meeting, the creditors vote for the appointment of the liquidator. So in actual fact, it is the creditors who appoint the liquidator, not the company, not the directors, and not the shareholders. That's why it's called creditors voluntary liquidation. And CVL for short is the most common procedure. Last month in the United Kingdom there were 1,600 liquidations, which is getting on towards all-time high levels. But it's a straightforward way of putting the company to sleep, bringing all of the affairs to an end. The directors are no longer in charge. The liquidator becomes the company, in essence.
As soon as they are signed with the liquidator, then they don't have any power as a director?
Well, no, that's not quite true. When they sign up to go down the liquidation path, there's that 3-week gap. They are still the directors in that 3-week gap, and they still have to exercise their powers and what's called fiduciary duty. In other words, not to make the creditor's position worse. At the creditor's appointment date, that's when the powers of the director stops. Now, the liquidator, he or she or they, have to then investigate the conduct of the directors in the period leading up to the insolvency, which is typically looking back up to 2 years. In that time, did the directors behave correctly? In that time, did the directors take too much money out of the company? In that time, did they make payments to friends that they shouldn't have paid? Those are called preferences. So each of these things is looked at, and the liquidator has to then report to the Insolvency Service, which is part of the UK government, on the director's conduct. Now, going back to company voluntary arrangement, there is no investigation into director's conduct. In liquidation, it is a statutory requirement. It has to happen.
That is a very good point which you mentioned. So, if the company has a number of assets and they don't want to liquidate the company, what is going to happen to those assets? Can they buy it back and start it again?
Well, the important thing to remember in a limited company is it's an individual person, if you like, in its own right. And those assets belong to the company. They do not belong to the directors. And often we see people and they'll say, well, I own these assets. Well, that's not correct. The company owns the asset. So what you can't do is to take that asset and put it in your pocket if it's cash. And you can't put it, if it's a vehicle, you can't take it and use it as if it were your own, because it belongs to the company, it has a value. So typically what happens is if there are assets in a liquidation, we will get an agent to sell them. And they have to sell them for the best value that they can obtain, which in liquidation, as I've indicated earlier, isn't always what you think it might be. It's quite significantly less. So to go back to the point of your question, can the directors buy the assets and start again? Well, the answer is yes and yes, but it's got to be done properly. You can't simply take the asset. This is called a transaction at an undervalue. You've got to pay for it. Now, it might be that you pay for it over time, and you would agree with the liquidator that you'd buy it over 1 month or 12 months or something like that. And it's got to be accounted for. So we can't just say, I think this asset is worth £1,000 and take it and pay £1,000 for it. So typically we would get a valuation done. So if there are material assets, you'd get a valuer to come in before the liquidation or just after, value the assets, and then the directors can offer to purchase them from the liquidator. Now, a dangerous step is where directors decide to avoid all of those steps and say, I will just buy it for what I think it's worth. Now that can be reversed by the liquidator once he's appointed, and not a lot of people know that. As to your other point, your other question, this is the most common question we get. In all of the calls that we have, this is the most common question. Can I be a director of another company? Well, the answer is yes, of course you can. You can be a director of as many companies as you like. What you can't do is take the name of the old company and apply it to the new company, because that is a criminal offense, unless you get the permission from the liquidators. And the liquidator can sell you the name, because the name could be an asset. So for example, ABC Bricks wants to trade as ABC Bricks in another company, the new company would buy that name from the liquidator. And if it's done properly, then there's nothing to worry about. But it's got to be accounted for.
So other than tangible assets, if there are any intangible assets, like the trading name, if the director still wants to use that name, would they have to pay for that name, or would the liquidator have to evaluate it?
Correct. And it's a good question, because a lot of companies don't have tangible assets like bricks and mortar or vehicles. They might have technology or a website. A website's a very good example. So what is the website worth to me? And it might be worth nothing to me, but it might be worth quite a lot to you if you wanted to trade I don't know, selling gentlemen's shoes or whatever it is online. So the brand might be quite valuable. Typically then you would get it valued, and the valuer would say, look, it has this number of views every month, it's got a lot of traffic, it's had generated a lot of business in the past, it's therefore worth an amount of money. And as I said earlier, the purchaser can purchase that from the liquidator for a fair value. That money is then put back into the company for and on behalf of the creditors. But intangible assets now are more common than tangible assets. In a lot of the companies that we see, there are no tangible assets. If there are tangible assets, then we would have to have them valued, such as property or vehicles or equipment or machinery, for example.
For example, in a situation where my company has a potential buyer, but they are not interested in taking on the debt, what can we do in this situation?
Well, this is quite common. We often see situations where there's been discussions going on between a potential buyer and the company. The company has built up a lot of liabilities and a lot of debt to its creditors, and the buyer will say, look, I can buy the shares of the company, but then I'll have the debt. I can buy the business of the company, then I won't have the debt. So typically we call this a business asset sale. And a business asset sale takes the part of the business which is valuable to somebody else and is sold. Again, typically, once it's been valued by an external valuer, it would be sold to the buyer. And the buyer is buying the business, he's not buying the company, because that's where the debt lives. Now, if the debt is left behind in the company, the smart thing to do is either to put it into liquidation or to use an administration process to do this whole sale process. Now, administration is more complex than liquidation, but it allows for an insolvency practitioner and valuers to come in, put a value on the business, put it out to a market. So we have databases of buyers in every sector where we'd say this business is going to be sold. Are you interested? Make a bid. So we create a market. And that's a fair way of establishing value. Often though, there aren't that many bidders, and it might be that the directors of the original company are the only bidders. And if an administration process occurs, they've got to go through fairly rigorous steps to make sure that they're buying it, that they've got the working capital to buy it, they've got the working capital to pay the wages in the future. But administrators can sell the business to any party. But so can liquidators. And sometimes administration is too expensive and it's too involved. And a liquidator can say, look, I've got a small business here, there are a number of potential purchasers, I will ask them all to make a bid and then sell it. Now, if it's down to continuity, that people say, look, I can't stop, then put it into liquidation and then sell it because I need to keep the business continuously running, then it can be done through a business asset sale without a liquidator being in place. So again, valuation, create a market, pay a fair value. That can be done before the company goes into liquidation or before it goes into administration. And often that will achieve a better outcome for the creditors because we haven't sold it with a liquidator's hat on, we've sold it as a business to a business.
We talked about the liquidation. If in a liquidation procedure, a director who owes money to the company, what happens to the money owed to the company from the director?
This is the second most popular question after the other one, which is, can I trade as a director and can I be a director of another company? Look, many accountants will tell directors to be tax efficient, you should pay yourself a minimum amount of PAYE deductible tax, salary, sorry. So you pay £12,000 a year, etc. And then the accountants will say, draw money out each month and pay yourself a dividend. Unfortunately, the second part gets forgotten in that they don't pay the dividends, and the dividends would be a reward to the shareholders for their investment. So what we end up with is the directors at liquidation time owe money to the company because they've drawn it out and they haven't taken it through tax and PAYE. This is very, very common. And unfortunately, most people think it'll just be written off. Not so. It is an asset of the company, it's a debtor, it is money that is owed to the company by the director. And again, directors get confused between company and themselves and they think that they're one and the same. They're not. So if they owe money to the company and it goes into liquidation, the liquidator must seek that money back. If it goes into a company voluntary arrangement, they must show in their CVA proposal how they intend to pay this back. And in HMRC's view, that should be taking no longer than 6 months, but we can establish a longer repayment period. In liquidation, the liquidator can say to the director, you owe the company £30,000, I want £30,000. But the director of that liquidated company may not have £30,000 or may not have the potential to earn enough to pay that money back. So in essence, it ends up being a bit of a bargaining discussion. How much can you afford? Show me your income statement, show me your asset statement, and then you will have to do a deal with the liquidator to pay some or all of that debt back. But this is a very common problem. And what I would always say to directors, if the company is displaying cash flow problems or it's displaying insolvency, you should not be taking drawings. You should put all of your salary through PAYE. That's the safest advice, because that means the tax is paid. If you then end up in front of a liquidator saying, I need £30,000 from you, this can lead to personal insolvency. We don't advise on personal insolvency, but there are people who will. And the reality is it becomes very unpleasant because the liquidator must get some recovery for the creditors.
When we go through the liquidation procedure, I as a director of the company might get a loan from a third party for my company, but I signed it as a guarantor. So what is going to happen to that loan where I was the guarantor?
This is very common. Most lenders nowadays, if they're not the larger banks, will automatically ask for a personal guarantee. So if the company is borrowing money, not including bounce back loans because there were no personal guarantees allowed for bounce back loans, but if the company borrows money from a lender and the director is required to sign a personal guarantee as a third party, if the company goes into liquidation and there's no money to pay that loan back, then the personal guarantee is called in. It's called calling it in. That means that the director then has to speak to the lending vehicle and say, I can pay some money back or I can't pay anything, etc., etc. They can pursue that director into court. They can take legal action for recovery. It can be quite unpleasant. And again, we can't advise directors on their individual circumstances because we are not permitted to do that. We act for the companies typically. But directors will, when they have signed a personal guarantee, they will have that problem to deal with. Now, in a company voluntary arrangement, as opposed to a liquidation, in a company voluntary arrangement, the company may continue to pay that loan, in which case the personal guarantee will not get called in, unless the company is unable to pay that, and then it might be written off by the CVA. So personal guarantees and directors' overdrawn loan accounts are very common, and directors need to be very aware that if they've had the money and or the company has borrowed money and they've guaranteed it, then they are liable to repay it.
In regards to bounce back loan and CBIL loans, there is a new situation and we get lots of calls regarding this matter. So as a director, am I liable for the bounce back loan and CBIL loans or not?
Well, let's split them into two. The bounce back loan was a very, very fast mechanism set up by the government to advance up to £50,000 to companies that were struggling during the shutdown of COVID. Now, this is companies from hospitality and bars and restaurants through to manufacturers. The bounce back loan is an unsecured loan. The company cannot provide any security to it, and nor did the directors provide any personal guarantees. So directors are not liable to pay back bounce back loans if the company goes into an insolvency process, any insolvency process. We get a lot of calls from people saying, look, I'm paying back the bounce back loan because I have to. And the answer to that is, you're wrong. You do not have to pay back the bounce back loan. It's a loan to that vehicle called ABC Company, okay? Now, the company goes into insolvency and it can't pay it back, the lender will get recovery from the government. If we look at the CBILS loans, this is a little bit more complicated, and CBILS loans ranged from £50,000 to several million pounds. And up to £250,000, there is no security in place typically. Although this morning we've had an inquiry where there is a CBILS loan and the bank took security, and we think that's an error. So up to £250,000, no security and no personal guarantees. Over £250,000, if you have a loan over that size, there may be personal guarantees, but it would depend upon the recovery. Recovery meaning how much does the bank get back from the company as to how much the individual person who personally guaranteed it might have to pay. And there are endless numbers of combinations of that, but the reality is if it's under 250, there should be no personal guarantees and no security. If it's over £250,000, then there could be. And clearly what you need to do is to speak to us, tell us what the issues are, tell us who the lender is, what kind of loan it was, when it was taken out, how much has been paid back, etc. And then we will give you advice on that on an individual basis. One thing I need to stress, Reza, is our initial advice is always free. We always give plenty of time on phone calls, and typically we will have either a video meeting or we'll go and see people to take them through all of their options. That's something which I didn't stress before. But there are no fees to pay for those initial discussions and initial meetings. So when you've got complex questions like C-bills and all the rest of it, give us a call because we can take you through those.
If I have had bounce back loans or CBIL loans and no other debt, can I just dissolve and shut down my company?
Well, you'd have to go through the liquidation process. The company has to go into liquidation. And if it does go into liquidation, remember it's the creditors who appoint the liquidator at a creditors meeting or a decision-making process. So the answer is yes, you can, but that means the end of the company, and it means that the liquidator then has to investigate your conduct. That's a statutory requirement. He then has to report to the lender and the creditors what happened, and the lender can then claim its guarantee portion back from the government, and in most cases that's up to 80% for C-bills loans and 100% for bounce back loans. But interestingly, the banks have to demonstrate to the government that they took all reasonable steps in the lending in the first place, but they took all reasonable steps in the recovery. So yes, if there's a bounce back loan or a C-bills loan and the business isn't viable, liquidation is probably the right solution. However, if the business is viable and we think it can be restructured, then we could look at a company voluntary arrangement.
So if the bank wants to get their money back from the government, they need to have that liquidation procedure done?
This is correct, and we see a lot of people getting advice from advisors and accountants to say, try to put the company into dissolution. Voluntary dissolution is a process, should only be used when there's no trading, there are no assets, there are no significant liabilities. So dissolution is not appropriate for bounce back loans or C-bills loans. And interestingly, we've seen a lot of letters over the last year or so from banks writing to companies to say, you must not go into dissolution, we will not allow it, and we have rejected it at Companies House. The company needs to go through a process, and that process typically is liquidation. If the company goes into liquidation, or if it goes into a company voluntary arrangement, or if it goes into administration, yes, the bank can then go and claim its money back, or the percentage that it's owed back from the British Business Bank, which is part of the government.
Now some people have been given the wrong advice and they had, for example, bounce back loans, but they have been advised just to dissolve their company and were told nothing is going to happen. Is this true?
Yeah, this is interesting. In the past, if a company had been dissolved from Companies House register, the creditor or HMRC or banks, for example, could apply to have it reinstated to the register to then put it into liquidation. Now, the government changed the law in 2021 to make that unnecessary, and the Insolvency Service can interview and demand information from directors of dissolved companies if they think the dissolution was not the appropriate tool. It should have gone through a liquidation. And we've seen a number of people being approached by the Insolvency Service and indeed disqualified as directors. So if some people have dissolved the company, that does not mean that the bounce back loan has gone away, because the banks will not be able to get their money back from the government if it's gone into dissolution, typically. So we're seeing a lot of people trying. They call us, we talk about a liquidation, they decide they don't want to do that because it sounds too difficult and too emotionally challenging, so they apply to Companies House, and or their accountants help them apply to Companies House to dissolve the company. And virtually every case, if there's any HMRC liability, HMRC will reject it. If there's a bounce back loan, the banks will reject it. So you're wasting 6 months, because it takes 3 months to apply and then 3 months notice to have the company dissolved. our strong advice in these situations is put the company into liquidation, and that will bring the matter to a close in what we call an orderly fashion. And you've not got this constant threat of will the insolvency service or the government pursue you for dissolving a company which had a bounce back loan. So strong advice, do not dissolve a company with a bounce back loan.
Let's assume someone who's had a bounce back loan, they just dissolved the company and it went through on the company's house. Now the government is going to look into it. Would you suggest they reopen the company and now take it through liquidation, or is it too late?
I think it's probably too late in many cases to do that. But it's a threat that it may be and the insolvency service comes along and reopens it or reinstates it to the register. I think the other thing to say is there are so many companies dissolved every year. Hundreds of thousands of companies are dissolved every year. So some will have slipped through. But no, I would get the right advice in the first place. Look at a liquidation, look at voluntary arrangement, but don't believe what people might tell you or friends might tell you. That you can simply dissolve it and the problem will go away. It will not go away. It is still there.
During liquidation, if my business address is registered to my home, will my personal asset become part of the liquidation?
Well, again, this is quite common. A lot of people will use their home as their registered office for the company. And this means that all communication about liquidation or any other matter, for example, loans or banks writing to the company, will do so at their home. Now, if the company becomes insolvent, there's a risk that creditors may send debt collection agents, or they may send high court enforcement officers to try and collect the debt. And generally, though, the company's assets and the individual's assets are completely separate, the fact that they're in that house is a danger, because somebody might come along and say, well, I'm taking all of these assets unless you pay this bill. This is called distraint. So they can come in and they can take assets. If it's your home, you can refuse access and refuse entry. But high court enforcement officers and agents have a lot of powers you've got to be very careful of. So if the company becomes insolvent and goes into liquidation, for example, we immediately change the registered office address to our registered office address, so that the liquidator becomes the company director, if you like. It's not quite true, but we move the registered office to ourselves. So I don't think it's a good idea having a registered office as your home, because it puts assets at risk. Although they're not assets that belong to the creditors, they're putting these at risk. And plus the fact is the emotional issue of having lots of people banging on your door or sending red letters and making threats. So it's not a wise idea to have a registered office at your home address, I would say.
In many cases, we see HMRC threatening the companies, telling them they are going to send a winding up petition. So what should they have done before, and what should they do at this stage?
The common complaint from everybody in our world is people leave it too late. So if you wait until the stage where HMRC are threatening to issue a winding up petition, then the debt has been around for a long time, because HMRC don't suddenly arrive at winding up petition just after a few days or a few weeks. Usually this has been ongoing for quite a long time. So the first thing that you should do, if the company isn't paying taxes on time, is give us a call and we can discuss how to fix those issues. What you don't do is to ignore it. And we see a lot of people who get a winding up 7-day warning letter saying we're going to wind the company up in 7 days if you do not pay. And they say, well, I thought I was in discussion with HMRC. Well, the reality is HMRC's run out of patience now, and they're sending a letter to warn you of 7 days before they reach the next step. Now, for 2 years during COVID and after COVID, winding up petitions were banned by the government. So HMRC could not issue winding up petitions, nor could landlords for tenants, arrears and so forth. Those bans have been lifted now, and HMRC, which used to be one of the most common petitioners, in other words, they would put the paper into court to start the action to liquidate a company. Very few petitions issued last year by HMRC, but they're now responsible for around half of all petitions being issued in the courts. But they're still at a low level. What HMRC would much prefer is to be talking to the company directors sooner about a time to pay arrangement, for example. And you will have negotiated many a time to pay arrangement where you take the HMRC liability and spread it out over a period of time which is affordable. Now HMRC will allow that. What they won't allow is multiple time to pay arrangements. They won't allow 2, 3 or 4 multiple time to pay arrangements if the first one hasn't worked. So if the first one hasn't worked, there's something fundamentally wrong with the business, I would suggest. And if there is something fundamentally wrong, is it cash flow? Does it have too many costs? Are there too many people? We can address those and we can help you reduce them. Or we can put the company into a liquidation if it isn't feasible. I think the worst thing you can do as a company director is to allow HMRC to issue a petition. Because what that demonstrates to HMRC is, it looks like you didn't care. And you just let the debt get worse and worse and worse. Now, one thing I haven't mentioned about liquidation is the liquidator can make the directors personally liable for the debt that they have built up. Now, what we do is we establish when the director should have known the company was insolvent. And this is quite a tough call to know when the directors knew. But asking for a time to pay arrangement in 2021 indicates that the company was insolvent in 2021. Moving forwards to now, if the company goes into liquidation and we can show that the director made the debt worse by, say, £50,000, we can ask the director to pay that £50,000 back to the company. This is called lifting the veil of incorporation. Every company has an incorporation veil around it. It's called limited liability. And I think most people know that limited liability means they act as a director or an officer of the company without personal risk. This is not true if you let the debt get worse and worse and worse and worse and don't act. We can lift the veil of incorporation and make you personally liable, and it is possible for us to take your assets, including house, cash, or any other assets, to repay the creditors in the liquidation.
When a company has no debt, no creditors, and no asset, but the company owes me as a director, in this situation, what should I do? Especially if the business is failing and the business is not proceeding well.
Okay. When we discussed creditors earlier, directors lending money to a company makes them a creditor. So that means that the company owes money back to them. Now, the director can make a number of choices. One, he can write the debt off and say, "Dear company, I have written the debt off." Okay. Two, you can put the company through a dissolution process, and that voluntary dissolution process is very straightforward because there's no HMRC liability, there's no bank liability, there's no landlord, there's no employees. So you can dissolve the company in that regard. All the director has to do is to not reject the application because he is a creditor. Does that make sense? Because he is a creditor, whether he likes it or not. But he can say, "Look, I'll write that debt off." So voluntary dissolution is an option in that situation where there are no assets, no material liabilities apart from himself or his family, perhaps. If we look at other liquidations, directors are often, as I said earlier, owed money by the company, as well as sometimes they owe money to the company. If they're owed money by the company, they're called an unsecured creditor, and that means if the company goes into a liquidation, they're unlikely to recover anything because HMRC's debt comes first, then all of the other unsecured creditors come below that. So directors may have to write it off in liquidation. But I said earlier about liquidation, it's the last resort, but it should not be delayed if the company isn't viable, isn't profitable, and is never looking like being profitable, then it should be put into liquidation.
Apart from the liquidation service which the KSA group provides, do you provide any other services or help for companies?
We do, and I think they are similar disciplines. So we have a finance brokerage called Company Funding Options, which is licensed and regulated by the Financial Conduct Authority, and we use that to go and find replacement products. So for example, a company might have had a relationship with a bank for a long period of time and that's not working very well, or an invoice finance facility and that's not working, and we can look to replace those. And we work hand in hand between KSA Group and Company Funding Options because sometimes there is no need for insolvency, there's no need for liquidation, there's no need for a rescue. We just need to restructure the debt, maybe take it out over a longer period of time and maybe a bit cheaper perhaps. So yes, if you're looking for new financial products and the company's got a bit of a cash flow issue, we would not put it into a liquidation scenario if we could find a way of replacing the current funding with something more appropriate.
When a company goes through the liquidation procedure, what will happen to the entitlement of the employees, such as redundancy? Are they going to lose it, or can it be saved?
Well, all employees are entitled to redundancy and something called lieu of notice. So that's how much notice they would have to be given if their job was to be made redundant or their role was to be made redundant. So if a company goes into liquidation, the liquidator will work with the employee to work out what their claims are for redundancy and for lieu of notice. And then you would fill out a form. It's called a redundancy payments form. And that gets sent off to the Redundancy Payments Office, which is another division of the government. And within a few weeks, the redundancy payment will be paid out to the individual. And the lieu of notice payment will be paid out. Now, there's a current limit on the payments of up to £579 per week. So if the employee earns less than £579 per week, they would get their full redundancy entitlement. Now, to be entitled, they have to have worked for the company for more than 2 years. Lieu of notice, they don't have to have been employed for more than 2 years. It depends what their contract says. So we call it the safety. I think the easiest way to call it is the safety net. There's a redundancy payment scheme that liquidated companies can use to pay out their employees. Now, interestingly, directors are also employees, and most people think as a director that's their job, but they're actually employed by the company, typically through a PAYE scheme. And if they're employed and they have paid taxes and NIC, national insurance, they too are entitled to claim redundancy. And that redundancy would be again paid for by the Redundancy Payments Office, part of government. Most people aren't aware of that. When it comes to making those claims and receiving the payment, it just depends how busy the Redundancy Payments Office is, but usually within 3 to 6 weeks those payments will have been paid out. So yes, I know directors are very worried about their employees losing their income, but the reality is there is a safety net. They will get some redundancy and some lieu of notice payments back. The employees also have another claim which is called a preferential claim. This is for any arrears of pay that they're owed to the date when their job stopped. And the company can pay that, or again the Redundancy Payments Office can pay that up to a maximum of £800 per person.
When my company is going through liquidation, when it comes to the cost of the liquidation which I need to pay, can it be paid through the selling of assets of the company? If there is no asset, who is then responsible to pay the fees?
Well, it's a common question, and the key to this is not to leave it too long. So if there's no cash left and there are no assets left and there's no funds to pay the cost of the liquidation, then either the directors can contribute towards it or the company can't go into liquidation, because liquidators have to be paid in advance for the work that they do to put the company through the liquidation process, as you can imagine. So if directors, for example, have a director's loan account where they owe money to the company, they can offset some of that by paying the cost of the liquidation. So that would be taken off the money that they owe. But the key question here is, why have directors left it right to the end when there's no cash, there are no assets, and there's no way of paying for liquidation? That's really not the actions that they should be taking. They should have been acting sooner. Further back down in time, they should have been acting sooner.
What is the general cost of liquidation?
Well, typically the procedure is one of paying for the statement of affairs, writing to all the creditors, dealing with employees, calling the meeting of creditors, and the typical fee is £5,000 if it's not a complex situation. That's subject to VAT, of course. Because we've worked with your firm for more than 10 years, we're happy to give a special discount to viewers of this video, so do get in touch. But the reality is that those sums have to be paid in advance, and then when the creditors have been appointed, or have appointed a liquidator, the liquidator can sell any remaining assets to cover the costs that go on afterwards. Because going into liquidation isn't the end of it. We've then got to look after the books and records, we've got to look after any assets, we've got to look into the conduct of the directors, and we've got to report to the creditors every year until the liquidation comes to an end. So they can come to an end within a year sometimes, but typically it's more than that. So the key question here is, don't leave it too long. Make sure that there's either there's some assets available which can be used to cover the cost, or that there's some cash available to cover the cost.
From your experience, what is your final advice for our viewers who are company owners and they are now struggling due to their companies not proceeding well?
The advice I would always give is similar to a medical situation. You should never put off going to see a doctor, because if you do, the situation could be much worse. So always get advice from a professional accountant or a professional advisor or a professional turnaround and insolvency advisor like KSA. And the reason is we deal with this all day. This is our work, and we know how to provide solutions and we know how to give you options. But if you leave it right to the end and rely upon the man in the street or your friend down the road, they will give you unprofessional advice and it won't necessarily be correct. We are legally obliged to give you the correct advice and to try and give you all of the options. And at the end of that process, it's up to you to make the decision. What do you want to do? And I would always strongly recommend coming to us sooner with, you've got indigestion, as opposed to coming to us when there's about to be a heart attack. So we can give you advice, we can give you guidance, and sometimes that's all it needs. We don't need to get involved in an insolvency process, because we've helped you with the diet and exercise, if you like, before the heart attack. So always get advice, always phone sooner, not later. And at the end of the phone, you'll find we're quite friendly people. We know how to ask you the questions so it's not too emotional, and we're here to help.
Mr. Steven, thank you very much for the time. Really appreciate it.
Thank you.